are unfortunately under persistent attack globally from systemic violence, displacements, and state-sponsored hate speech to the marginalization of vulnerable groups. These violations threaten our shared values as to human rights. Human rights are not just only abstract principles, as you know. They are the foundation of freedom, justice, and peace. Human rights organizations, like the others, are at the forefront of these efforts, and we are working tirelessly to amplify the voices of the oppressed, document abuses, and as much as we can, we are trying to advocate for justice on various international platforms. Our first panel today is called The Role of the UN in Preventing Human Rights Violations. The United Nations remains a cornerstone of global efforts in protecting and promoting human rights. Its mechanisms, however, have seen varying degrees of success, from addressing the Uyghur crisis in China and the gross human rights violations in Turkey. While the UN provides a vital platform for advocacy and accountability, it often faces significant challenges in enforcement, and of course it faces political resistance as well. Our panel today will explore such challenges and through case studies and provide critical analysis of the issues in an effort to find out whether any progress can be made and how international mechanisms, such as the UN mechanisms, may be strengthened. I'm delighted to introduce our three distinguished speakers today. Monsieur Samuel Cogolati. He is a co-president of ECOLO. He is a former member of the Chamber of Representatives of Belgium. Monsieur Cogolati is a passionate advocate for international justice, and he has been a vocal supporter of human rights initiatives, particularly in addressing systematic violations and promoting accountability in the Uyghur cause. Today, he will discuss the UN's response to the Uyghur crisis, offering a detailed case study that highlights the challenges and opportunities in international accountability mechanisms. Our second guest is Dr. Katayoun Formica Hosseinnejad. She is a human rights advisor at the International Association for Human Rights Advocacy in Geneva. She holds a Ph.D. degree in international law and human rights law. With years of experience working within the UN system, she has developed expertise in human rights frameworks, international law, and advocacy strategies. Her presentation will provide a comprehensive overview of the UN's human rights mechanisms, including their structure, potential, and practical obstacles in addressing global human rights issues. Last, but not definitely the least, Haşim Tekineş. He is a policy analyst at Institute. He specializes in human rights and international relations. He's a former Turkish diplomat with deep understanding of the dynamics of Turkey's human rights landscape and the effectiveness of international mechanisms in addressing violations. He will critically evaluate the role of the UN in responding to Turkey's ongoing human rights abuses, identifying both challenges and opportunities for systemic improvement. I will encourage you to engage effectively in sessions, and don't be shy. Share your thoughts and ask as many questions as you can to make most of these distinguished guests. Without further ado, I'm pleased to invite our first speaker, Monsieur Samuel Cogolati, to begin his presentation. The floor is yours.
Thank you so much. Hello, everyone. Good morning. It's for me a great honor to be with you this morning. I'm very happy to be here on your beautiful campus, and thank you also for organizing this important human rights forum. As you just said, Mr. Chairman, human rights are really close to my heart. I have devoted my PhD to the study of international human rights law in Leuven, but I also spent 5 years within the federal parliament, in the House of Representatives in Brussels, to fight for human rights causes all around the globe. I also had the honor to chair the Human Rights Committee of Parliamentarians at the IPU in Geneva. And for me, it was really important to use all mechanisms available to fight, to prevent atrocities, but also to fight against human rights abuses. And I just want to take a short moment with you this morning to explore one specific example of a deep and long human rights crisis, that is the genocide of Uyghur people in China, in the province of Xinjiang. Some years ago, I was elected in the federal parliament. That was in 2019. And on the very first day after my election, I got in touch and I got contacted by a father who's a Uyghur refugee here in Belgium, in the beautiful city of Ghent. And this father told me that his 4 children and his wife got arrested within the Belgian embassy in Beijing by the Chinese police. You must know that even today, his family of his wife, 4 children, are still under house arrest in Urumqi, so the capital of the province of Xinjiang in China. But I was alerted by his story, and through this man and through this very courageous father, I also got the opportunity to meet with the larger Uyghur community in Belgium. And I must be very transparent with you. I didn't know much about the Uyghur community in Belgium. I must say that most traditional media in French-speaking Belgium didn't speak much about the Uyghur people. And so I was really unaware of the large extent of atrocities committed by the Chinese Communist Party against this group of people and against this ethnicity, simply because of their religion and simply because of their beliefs and other language. So I wanted to do something. I wanted to do something in my capacity as a member of parliament. And I decided, because I was, I had this doctorate in international law, so I decided to analyze the case in a proper legal manner. And I thought it was a good time to introduce a new resolution in the parliament in Belgium to recognize formally crimes against humanity, but also a crime of genocide. And that was an important step. And I want to tell you that sometimes the UN system of human rights protection, just to connect with the other panelists, often gets kind of stuck because it relies heavily on the cooperation of member states. You know that international law puts in place a horizontal system, so there is no vertical system of application and of enforcement of human rights clauses. So we depend heavily on the cooperation of UN member states. And that's where you can see that powerful countries like China can exploit systemic weaknesses of the UN human rights system. If you think of the specific case of the human rights crisis against the Uyghur people, it is of course completely unlikely and unimaginable to see a domestic tribunal within China take the case of the Uyghur crisis seriously and to apply, for example, the 1948 Genocide Convention. Unfortunately, it is also unlikely to see an international tribunal like the ICC or the ICJ in The Hague to hear the case because simply China will never be compelled to participate in this case. And you know that China also holds a veto power within the UN Security Council. And so it is also very unlikely to imagine that, for example, the UN Security Council will ever one day refer the case of the Uyghur crisis to the ICJ. So this leaves us with a very important question. What can we do in democratic and human rights loving countries like Belgium in order to enforce international human rights norms and important conventions like the 1948 Convention Against Genocide? And it's where I think we should not neglect and we should not overlook the power that we have in a democratic parliament like the House of Representatives in Belgium. And it's where I think we should take a responsibility as a country indeed to recognize the ongoing genocide against the Uyghur people, but also against other people, and maybe we can talk about it later in the Q&A session. But just to let you know that that was not an easy process. And I must be honest with you, in the very beginning, I remember that was in 2021, when I really ended drafting my text and my proposal of resolution. I thought this would never go through the parliament because the case would be way too controversial. And I remember when I really submitted the text, when it became official and public, that was a Friday, I remember very well. The press commented about it, and the press asked other political parties, what will you do with your vote regarding this text? And most other democratic parties said, well, I think this guy, so Samuel Cogolati, goes a bit too far. I think he exaggerates a bit too much, and we will probably abstain. More dramatically, we also received on the very day of the deposit of filing this new resolution, a call from the Chinese ambassador in Belgium, and the Chinese ambassador formally requested the Speaker of the House to retract the document and to retrieve the motion from the agenda of the Parliament. Of course, that is highly exceptional. You will rarely see a third country intervene in the internal parliamentary affairs of a country like Belgium. A bit later, in March 2021, and the debate was still ongoing, the European Commission and the EU decided to impose sanctions on 4 Chinese individuals responsible for atrocities, namely the arbitrary detention of millions of Uyghur people, including children and women, in camps in China, simply because of their religion and their ethnicity. Those 4 people are still being sanctioned now by the EU, but China decided to reply with counter-sanctions, with a list of 10 individuals in the European Union, and I was surprisingly part of them, simply because I decided to raise my voice in favor of those Uyghur people. I also got sanctioned by China in 2021. Now I can tell you, even though I was a bit shocked at the time, my partner and my family as well, because my family, by the way, got also sanctioned. I don't know why. Apparently that's standard Chinese practice. But I must say that now I should thank China for the publicity they made about my resolution. Without that publicity, without the media attention that they actually triggered on my resolution, I think my resolution would never have been adopted. And so it was really interesting because that really triggered an interesting case and an interesting debate in the Belgian parliament. We had for the first time the opportunity to hear a victim of the camps. So Kelbi Noor Siddiq, I think you should really meet with her if you have the opportunity. She lives and she's a refugee in the Netherlands. She's a wonderful, very courageous woman. She only speaks Uyghur. By the way, it's a language that's really close to the Turkish language. But she got translated in the parliament, and she got the opportunity to talk openly about what was happening within the camps in China. And she actually convinced all democratic parties in the Belgian parliament to vote in favor of my resolution. Just one exception, the Communist Party in Belgium, PTB, PVDA, really close-minded with, of course, the Chinese ruling Communist Party, so they decided to abstain, but all other parties decided to vote in favor of that resolution. And I must say that other MPs in the world decided to copy-paste, actually, our resolution. And so we saw, for example, the French National Assembly, the Assemblée Nationale in Paris. They also adopted the same text a few months after. So we saw kind of a movement in other national assemblies, in other national parliaments, adopting the same kind of stance. All this to say, and I will conclude with that, but I really look forward to the discussion afterward and to the Q&A session. But all this to say that we also have a responsibility at our domestic level, at our national level, to take human rights seriously and to apply international human rights conventions, also within our national parliaments. We often think of David against Goliath, right? When we think of huge human rights abuses, like, for example, the ongoing war and genocide against Palestinian people in Gaza. But we actually have powers, especially here in Europe. We often forget that the EU still is the first commercial market in the world. And so we do have a responsibility to protect and defend human rights in our national democracies. And that's just the call I wanted to share with you today, because I am an educated international lawyer, but I am now a politician. I chair the Green Party in French-speaking Belgium. And I really believe that we as politicians in democratic countries like Belgium do have a responsibility to speak more openly and to raise the tone and our voice about human rights crisis, not only in Belgium, not only in Europe, but also all around the globe. Thank you very much for your attention, and I look forward to the discussion afterwards.
Thank you. Thank you, Mr. Cogolati. Now, Dr. Katayoun Hosseinnejad.
Thank you. Look, this one seems no. Yeah. Good morning, everyone. Thank you, Mr. Chair. It's really a pleasure for me as well to be here with you and with this distinguished panelist. I think I can share your feeling that we were all very impressed by what Samuel has shared with us, all the activities, all the efforts and initiatives that taken. And I'm very happy to be in Brussels, Belgium, which is really the pioneer in taking initiatives, in making, ensuring the respect for human rights or stopping the violation of human rights. We know the cases, for example, of taking initiative of universal jurisdiction of the Belgian court is well known internationally, even discussed at the level of the International Court of Justice. So it's really a privilege for me, definitely, to be here and to discuss this topic with you. I also would like to thank the Solidarity with Others for the warm invitation to discuss, to talk with you today. I had a presentation, but it seems that it's not working. It's off. So So in this time, I would like to thank you. So I would like to share with you a bit more a perspective or a brief introduction about human rights mechanism, procedures, and system that exists at the United Nations. So it would be a very brief review or overview of what exists at the UN. And I would look forward for further discussion during our question and answer if the time allows. So the UN human rights mechanism, we can say it's divided based on the two different kind of pillars. One is the mechanism and the system that are established based on the charter, what we call charter-based bodies, and the other one are treaty-based bodies. Of course, when we say treaty-based bodies, we don't mean that the charter is not a treaty. The United Nations Charter is a treaty, but when we talk about treaty-based bodies of like different human rights bodies that created, we are talking about the organs that are created by specific treaty, and these treaties are the 9 core human rights treaties that address the main topic of human rights. We will go further in details about that. The first pillar are what are the organs or the bodies that are created based on the United Nations Charter. In this topic, we mainly talk about Human Rights Council, which is the body within the United Nations who would address all the topics related with the human rights implementation and development. I would start with Human Rights Council. So Human Rights Council was established in 2006 as a kind of a replacement of the Commission of Human Rights that was existed before. Human Rights Council is a body established by the General Assembly. So within the structure of the UN, it will be part of the General Assembly under the supervision of the General Assembly. In this way, the binding of each resolution or its adoption or recommendation would have the same kind of value of the General Assembly. We can discuss this further about the effectiveness of human rights decision at the UN. Human Rights Council is composed of 47 members that are elected for 3 years, but every 1 year, 1/3 of these members will be re-elected by the General Assembly. At the moment, just yesterday or 2 days ago, the new president of the Human Rights Council was elected, who will be Switzerland. The Human Rights Council has a very broad mandate. It reviews all the issues related to human rights of all the countries, UN member states, and can address the general topics, but as well as specific issues in their special sessions, and make a recommendation, make a resolution, adopt a resolution about issues that would be a concern. I would address 3 main mechanisms or bodies that work under the Human Rights Council, that are we can say also they are the main mechanism for monitoring the human rights implementation at the national levels. The first and most important one is the UPR, Universal Periodic Review. This is an initiative of the Human Rights Council. It was created in 2006 with the creation of the Human Rights Council. So it's unique in a way that in the Universal Periodic Review, all the implementation of human rights of all states will be reviewed by all states, in theory. The idea is that every state, during the cycle of the review of UPR, will be reviewed, and their implementation of the human rights will be assessed. A recommendation will be made based on the weak points, based on the advancement. During this process, not only the member states should provide reports, but also the civil society, as well as experts of the UN who would provide information to the working group that would review the state practice. Now we are in the 4th cycle of the review. Every year, around 42 countries will be reviewed by the Human Rights Council during the session. So now we are in the 4th review of the cycle of all the countries, meaning that for 3 times, the human rights practice of all the countries around the world have been reviewed by Human Rights Council. In addition to the UPR, Human Rights Council also has the power to establish special procedures. Special procedures are independent experts. They are not staff of the United Nations, but they are mainly independent experts in their field who would give advice, recommend, or address a specific topic or issue that is of a concern for Human Rights Council. At the moment, we have 46 thematic procedures, meaning that it's not they focus on different subjects. So their reach is not limited to a specific country. For example, we have a special procedures on terrorism, on special rapporteur on, for example, independence of judges. They won't necessarily are limited to the act of one state. So they review the practice of all states around the globe. And at the same time, the Human Rights Council, depending on the human rights situation and the concern of each state, they may assign a special rapporteur for specific countries. So far, at the moment, we have 4 countries. It's again off the if no problem, but it's good for them. So at the moment, there are 4 countries that have a special rapporteurs that only focus on the situation of human rights in these countries. So these special procedures are also important mechanism for the monitoring and implementation of human rights law. What they do is that they can do the country visit, so they would request the country visit to the country of concern. Of course, they cannot enforce their request. In order to conduct a country visit, the host country should accept them. They send a kind of communication different communication to a state depending on the level of implementation or violation of human rights. So these can be allegation letters. If they have credible information about the violation of specific human rights issue, they can send a communication about that. And they also develop a kind of, or develop the norms and standards on human rights. So the reports of special rapporteurs, for example, special rapporteurs on food, special rapporteurs on terrorism, they are all very important for the advancement and development of the human rights norms as well. Within this procedure, we have 2 main working groups that are also very important because they accept individual communication. One is working group on arbitrary detention, which review the practice of states at national level about detention. So it reviews whether the detention of people for whatever reason can be considered legally or according to the human rights law. From that perspective, it can accept communication from individuals. The other working group that is also accept individual complaints or communication is a working group on enforced disappearance, enforced and involuntary disappearances that's also established long time before Human Rights Council by the Commission for Human Rights, both of these working groups, and they accept, among other activities, they also accept individual communication. The third other important organ or body within the Human Rights Council, which is also very important for monitoring and reviewing human rights implementation, is independent investigation that Human Rights Council can establish. So at the moment, there are around 14 investigation mechanisms that Human Rights Council has created. Before there were other mechanisms. These investigations would have a specific mandate on a specific country, and for example, they do a fact-finding mission, which is very important for example, for the case of Syria, to record the cases of violation. For the case of Ukraine now, we have, for some state, depending on the situation, there will be only a group of human rights experts which will assist specific aspect of a government to address a human rights problem that exists. So this is a very brief introduction to the Human Rights Council mechanism. I hope it's not too complicated. Then I would go to the second pillar, which is all the structure that exists under the treaty-based system. So we have 9 core international instruments, human rights instruments, that address different aspect or topic of human rights law. So we have, you are very well know, we have 2 main covenants. One of them address the civil and political rights. One of them address the cultural and economic social rights. And other conventions, Convention Against Torture, Convention for Rights of Disabilities. Within these conventions, it is foreseen that a committee will be established to oversee the implementation of these conventions, these treaties. The big difference between this system than the previous system or the previous pillar of Human Rights Council is that it's only binding for the states who have adopted or have accepted to be a member of these treaties. So countries who are not member of a treaty, for example, if Convention Against Racial Discrimination, a country is not a member, the committee established by this treaty cannot review its practice. So this is the main difference between the two systems. The other main difference of these committees that are established based on the treaties are that they accept individual communication as a kind of a quasi-judicial procedure. So they don't act like a court. So if you compare them with the European Court of Human Rights or International Court of Justice, they are not the same as a court, but they still have a quasi-judicial character, meaning that they issue decision, they review the practice, they receive the responses from states, they receive the information from individuals, they make their assessment, but at the end of the day, they issue a view and not a decision. So there are always a kind of a discussion between international legal scholars about the binding character of these views and these decisions. But still, what is very important that these committees, that are created based on these treaties, yes, I will wrap up in 2 minutes, are increasing, are contributing a lot to the jurisprudence of human rights. So I still have a more complicated slide. I won't talk about it. So it's a difference about these mechanisms and the review that carried out by human rights committees and other ones. So I would leave it to the discussion, and I will end up here. And thank you for your attention and patience. Thank you.
Thank you. And
thank you.
Finally, Mr. Haşim Tekineş.
Thank you for solidarity with others for giving me this opportunity for being here, and I'm very honored to speaking before you and being among these distinguished speakers. And I will more talk about the United Nations positive role in the Turkish context, especially after 2016 coup attempt. As you know, although the international pressures has so far failed to bring back Turkey from the path of authoritarianism, but still these international bodies, international institutions still have an important role in the Turkish context, especially for the victims. As you know, since the early 2010s, Turkey has been going backwards in terms of democracy, human rights, and rule of law. And the 2016 coup attempt has been a milestone in this trend. Since then, the Turkish government, using this coup as an excuse, has initiated a crackdown, a massive, brutal crackdown on its opponents. in Turkey, and hundreds of thousands of people have undergone terror investigations on the grounds of baseless accusations without any proper evidence. And the Turkish security apparatus use torture, rape, and mistreatment and abductions in a massive scale, in a very systematic and widespread way. So, to further intimidate the victims, the Turkish government has not only targeted the designated individuals, but also their families too. So it turned into a collective punishment for the certain dissident groups, and to expand this collective punishment to the rest of the society on societal level, the government has made any social and economic interaction with its dissidents as a more costly for the rest of the society and for, if possible, for international actors. So in such an environment, of course, the international institutions like European Court of Human Rights and the United Nations play a very important role. Although the European Court of Human Rights is the key actor in addressing the human rights violations in Turkey, the approach the court uses can be sometimes slow and limited. In contrast, United Nations mechanisms can be more effective in some cases. In the Turkish context, of course, after 2016 coup attempt, the persecution, the primary target of the persecution is the Gülen group, Gülen movement. It is a social religious group led by Fethullah Gülen, who passed away a few weeks ago. And the government accused the Gülen movement for organizing the coup attempt in 2016 and designated it as a terrorist organization. And of course, the movement rejects all the accusations and asks for an international investigation. In this environment, since 2016, the United Nations mechanisms have identified significant abuses many times against the Gülenists in Turkey. And so far so that United Nations even decided that the practices, the policies that the Turkish government implement against the Gülen movement has amounted to the crimes against humanity. It was a very important decision to understand the gravity of the situation in Turkey. So the United Nations mechanisms also has been more effective in the issue of abductions. As you know, in cases of abductions, acting swiftly is very important. And United Nations, compared to other international bodies, I'm more talking about European Court of Human Rights here, can be more effective here. As you know, after 2016 coup, abductions become a more common practice for Turkish government to target the Gülenists, both in Turkey and in the world. And the Turkish intelligence target a certain individual and takes him or her to a certain unknown place for further interrogation, which means actually a heavy and systematic torture without any access to any legal protection. So to have a better grasp of UN's role, I want to talk more about a specific case of Yusuf Bilge Tunç. Yusuf Bilge Tunç was a public servant until 2016. And in August 2019, he was abducted by unknown people in the broad daylight of Ankara. So since then, we have not heard of him, no news since then about him or his whereabouts. But all the details and the profile of the victim and all the patterns of the incident indicates that it was a covert intelligence operation. So the the family take the issue to the European Court of Human Rights. But unfortunately, the European Court of Human Rights decision was disappointing for the family because the court rejected the application since claiming that that there was no clear evidence that Yusuf Bilge Tunç was under the control of Turkish security forces. And the court also mentioned that they relied on the investigation that Turkish authorities has run. But that investigation, yes, Turkish authorities made an investigation. I mean the Turkish police and the prosecutor's office. But it was too late. It was months after the incident, and until then, the critical evidence have already gone missing. And I don't need to say. I don't feel to say that the authorities were very reluctant to take the issue, and the Turkish intelligence role in this possible role in this incident was never a subject of investigation. So, in contrast to United Nations, European Court of Human Rights role, the United Nations took a more positive role and criticized European Court of Human Rights decision in this case, in the Yusuf Bilge Tunç case. And yes, of course, the United Nations did not take the issue, officially take the issue, but two of its members, the committee members, criticized the European Court of Human Rights decisions, the reasoning the court used in this decision. And they pointed out that the court failed to consider well the general environment in Turkey, general environment of repression and abductions, and of course the investigation. Investigation was just a formality; it was not a serious one, and the court should assume that the victim was abducted. So, as you already mentioned, the United Nations decisions, committee decisions, do not have the same legal weight that European Court of Human Rights enjoy, especially for Turkey. And but still, these decisions play some important role in Turkey. First of all, they put a diplomatic pressure on the Turkish government. Yes, the Turkish government usually dismiss such decisions as biased against Turkey, but still, it reminds the government, the bureaucracy, the authorities that their actions do not go unnoticed. They are recorded somewhere internationally and at some authority. So it is important reminder for them, and also. In such decisions, in such international investigations, the government needs to give some kind of response for the accusations, and this led to some internal deliberations. Of course, to prepare a response, you should start and initiate an investigation, internal investigation. And these deliberations also cause some pressure on the different units within the bureaucracy. So it kind of cause a restraint for the authorities to be more careful in their actions and decisions that could abuse human rights. And at this point, I should also mention that Turkey is still the part of Western political, economic, and security architecture. And the Turkish economy, it is still very weak, and it is still very dependent on the Western economies. Half of Turkey's trade is with European economies. And Turkish army, Turkish military is still a NATO army. It's still using the NATO weapon and defense systems. And the Turkish defense industry, it is growing, but it is still dependent on NATO and Western defense industries, the Western economies, for critical technology and licenses to export their own product. So in many ways, Turkey is dependent on the West. It is still, despite all the authoritarian regression, it is still part of the Western system. So the Turkish government is still careful about its international image. So all these decisions from international bodies put a significant pressure on Turkey. And secondly, these kind of decisions from UN or European Court of Human Rights give the victims a sense of justice. In a system they feel forgotten, ignored, and vilified. And I think it is important. In addition to their psychological value, these decisions also legitimize these victims and their families in their, not only in their struggle for human rights, but also in their social and economic relations, and it makes huge difference for those people. And lastly, it helps these decisions, UN decisions or European Court of Human Rights, these decisions help the third parties to better understand Turkey, because the Turkish government conducts a kind of international propaganda war against the victims to convince the third parties, other governments, other states, to cooperate in its persecution against the dissidents. So while this propaganda confuses people and makes makes understanding Turkey very difficult and complicated, these decisions from UN or ACHR can be a useful reference source for these people. Yes, Turkey is going authoritarian with every passing day, and I think this makes the role international bodies play more important, more crucial. Yes, they cannot roll back Turkey's authoritarianism, but still they make huge difference for the victims. Thank you.
I'd like to thank our panelists here. So I think I can open the floor for questions. Anybody with a burning question? Because I have a few myself. So okay. Samuel, I was making a note of your speech, and I mean, does it really? Do the stars need to align for us to get some sort of success against states like China? Because you were talking about this resolution, and it's a huge success. So, what do you think you owe most the success of this resolution? What happened that you managed to get this through the parliament?
Well, thank you very much for this question. First of all, I think I need to remain very humble and modest here, because it's a non-binding resolution. And let's be honest and transparent. I mean, the situation is still ongoing. The camps have not been closed, and millions of people, innocent people, are still arbitrarily detained in those camps. So that's the first thing I want to mention, just to be sure that we're on the same page here. Now, it is true that the passing of the resolution was a success, but as I said, I think that paradoxically and quite bizarrely actually, the success is probably due to China itself and to its very poor understanding of how a democracy actually works in European states and Belgium. I think that by sanctioning me and sanctioning other democratically elected members of parliaments in Europe, they actually attracted a lot of attention, a lot of media attention for my work and for what I was doing. Let's be honest, a few years ago, nobody could care less about what was happening to the Uyghur people very far away in that province, in that western province of China. So I think that China actually provoked itself the movement for the huge media attention to the current crisis. But I think we should do way more, and I think we have way more in our power. Just to give you one example, as I said, we're a huge trade power in Europe, and actually we're buying most of our products, for example, our T-shirts, from China. And you should know that those products are actually issued from forced labor, and mostly Uyghur forced labor. And so we do have a possibility there to stop imports of products from forced labor. And that's, easy legislation that can be enacted at EU level, but also in Belgium. Just to give you another very simple example of how we can change the law actually quite easily. You should know that slavery in Belgium is forbidden. It's a criminal offense to enslave anyone here in the room, for example, okay? Thank God, okay? Now it is not forbidden to import products knowingly issued from forced labor. And that's a problem, I think. And so it's very easy to change the criminal codes in order to extend the scope of application of the prohibition of slavery in Belgium. And that's something you can do actually quite easily. I submitted, again, a bill in the parliament when I was in parliament during the last legislature. Unfortunately, I was not able to pass that law, but that seems to be seriously a no-brainer. When some corporation knows that its products are actually made by slaves, modern slaves, well, I think that the prohibition of slavery should strictly apply to those corporations as well. Just to give you some examples of the legal tools we have at our disposal in order to enforce human rights provisions, international human rights treaties, of which you were speaking about, more efficiently, more effectively, domestically. Thank you.
Anybody? Okay. So, is that okay? Sorry. Yeah. Okay.
Yeah, my question goes to the first speaker. I was following Turkish media and Turkish government statements when the issues in Uyghur started. But then after that, the Chinese government gave billions of dollars to Turkish government. Then they stopped criticizing China over Uyghurs' problem. Then they also started deporting people from Turkey to China, Uyghurs, I mean. Well, that's just the information, but my question is about there are not many people defending human rights issues all over the world. There are very dedicated people doing these kind of things. But what should we do? What might be done to just enlarge and just to involve more people to defend human rights violations all over the world? Thank you.
I think as a human rights lawyer, I can just say, look, silence is not our side. It's not on our side. So I interpreted what Samuel was saying was we need to keep rattling the cage of these dictators. Yeah. So we need to find different mechanisms, and we have to apply these mechanisms as successfully as possible. And we have to do it, in a organized way, and we have to be persistent, because the people that we are dealing with in terms of human rights violations, they are very, very persistent, and they are very coordinated, and they seem to help each other. So I sometimes believe there's a textbook for dictators or something like that, because they're all reading from the same page. This is what I see. And I have a question regarding the UN and the European Court of Human Rights. I mean, don't get me started about the European Court of Human Rights, but anyway, so it's there, a mechanism, and to a certain extent, it has been successful in certain cases. But my view, my experience as a lawyer is Turkey has been more reluctant in implementing ECHR decisions than UN working group resolutions. maybe Mr. Tekineş, you might want to elaborate, because you touched upon that, but why is the Turkish government is more inclined to implement UN resolutions rather than European Court of Human Rights judgments?
Yeah, it is maybe still early to decide whether Turkey accept the European Court of Human Rights decision, because it was last year, and probably we need probably more data to see the performance of the courts in Turkey. But what I mean is sometimes our expectations are too high. Rightfully, of course, we have all the right to expect return to democracy and respect to human rights, and respect to the decisions of European Court of Human Rights and other international bodies like UN. And usually we fail to see that, and because the authoritarian governments, of course, like Turkey or in China or in other place, usually ignore such decisions. But our expectations shouldn't confuse us about their success, because their success can be more felt by victims than seen by our sides outside. Maybe we can't see any change in numbers of arrests, and maybe still, unfortunately, some people under torture. But certain people feel in the field, in the maybe prison, maybe their prison conditions are changed, maybe they are released earlier than expected. These kind of small changes can help the victims a lot. And I'm not a Chinese expert, but I heard a similar experience from an Uyghur friend when the United States few years ago put a sanction. He said several of people he knew was released from Chinese prisons just after that decision from US to just ease the pressure. And maybe we from outside we don't see any change in the general number statistics, but on the field, the people, the victims, the individuals and their families can feel their impact, their positive impact. So this is why I still find all these decisions, all these mechanisms, international mechanisms, very valuable.
Thank you. And yeah, I've got a few questions. Yes, Lisa.
I think I'm not going to need the microphone. Sorry. I'd like to ask Samuel whether he faced any consequences of the Chinese sanction in Europe. I'm asking because I know a lot of Turkish lawyers, academics, business people living in Europe or even in the States who are listed in wanted lists of the Turkish government, which is online. And these lists, wanted terrorists lists, have been collected by business intelligence companies, and they have been circulated, for example, to banks, to other, business circles. And I know people who can't, for example, sell their cars, who can't get a loan for a mortgage, or even open a bank account. Or I know people whose bank accounts have been closed because of such business intelligence activities. And I'm just wondering if the Chinese sanctions have had such impacts on you.
No, I should be honest, the impact was quite, not that important. Beside the fact that I cannot go and travel to China, and I cannot, indeed put my money on a Chinese bank account, but that's quite okay. I also suffered cyber attacks from a group named APT31. It's basically the Ministry of State Security in China. And I became aware of that because of an investigation led by the FBI in the US. That was quite mediatized just a few months ago. But besides that, I must be very honest with you. I mean, I'm all fine. That's why, I mean, the problem is really not myself. And I recall that for me, the sanctions were more, you know, kind of a political opportunity in order to raise more attention on the case of the Uyghur crisis in Belgium. But really nothing comparable to what the Uyghur community itself is, you know, is having as problems here. Because when you talk with them and you realize that they get calls from their family members, from brothers, from sisters, from cousins, who risk going to the camps if they don't act according to the directives of the Chinese police on the phone, well, that's, you know, it's something completely different. So again, I cannot complain.
I think we are running out of time, but sorry, just one more question to Dr. Hosseinnejad. Because I know there are quite a few representatives of NGOs here, and so if it's regarding, yeah, Dr. Hosseinnejad, yeah, yes, please, yeah.
No? Yeah, all right. So during your speech, you mentioned how significant is the existence of the United Nations in the sense of addressing and tackling the human rights violations. So when it comes to that, one of the main ways which was being used by the UN is UPR, Universal Periodic Review, as you mentioned. So as for the UPR, so the reports which was being provided by the independent entities is quite important, and it has its unique place, right? But these reports are also coming from the NGOs which works in the borders of the states which doing the violations itself. So how can we overcome the possible oppression and any other types of activities which can be provided by the governments itself? Because in the case of Mr. Samuel, despite the fact he's not working under the UN, but he was oppressed by a government, by a foreign government. So how can we overcome this kind of problems? Is there any specific procedure which was being implemented by the UN? That was my question. Thank you.
Thank you for your question, and I think I would try to answer it with a kind of a global response that relates to all the human rights actors. Nowadays, fortunately, within the human rights mechanism, it is well accepted and recognized that we cannot accept all the narrative, all the information only from the state side. So on all the process that I have mentioned, all the reviews that carried out by Human Rights Council or the treaty bodies committees, of course, the state has to provide information, but the civil society and actors, NGOs, can and should provide information. How we can change the narrative, how we can change the kind of information that states provide, because they have a monopoly about the information. They have access to all the information, and an NGO, especially if you're outside, you have less connection. First of all, within the human rights mechanism, there is always a kind of presumption that because states control everything, especially detention places, not all the information is accessible to public. So sometimes even if you make a credible allegation, even without providing all the evidences, they would accept it as allegation and they would raise it against the state. The second point is, which is very important, is the quality of the work of the civil society and human rights actors. Definitely, for example, if we talk about the UPR, when there is a specific country which will be reviewed, there will be huge numbers of reports, even provided by the civil society. So in order to not to miss the point, because sometimes countries or the working group would receive so many information, so NGOs should address these kind of issues, look at it strategically, how to raise the problem while not overwhelming the working group with so many information that at the end of the day, they wouldn't even read the document. So these are the practical problem that exists. But if I would use, for example, the example of Turkey, recently there was a review of Turkey, the second periodic review of the Turkey by Human Rights Committee. And if you look at the concluding observation of the committee, the finding is amazing. And I think finding all these violations, which are very correct, and sometimes it's lower than what is really happening, but still there are lots of concern that raised by the committee, is the result of what the NGOs and civil society had did. So there are venues that are present, definitely. Thank you.
If it's going to be a very quick one, because we've run out of time.
Yes. I'm quite surprised when you said that the importation of products issued of forced labor are not forbidden in Belgium. As far as I know, EU Parliament adopted in April new legislation regarding this point, and not just when there is clear violation, but when there is suspicion of forced labor. So could you clarify, is it that is not just Belgium has not ratified it yet and it's not implemented, but is it on the way? Thank you.
No, it's just that you should draw a legal distinction between a trade regulation at EU level, which is indeed in force and which is actually great news since last year. After a very long fight in the European Parliament, including by my colleague Saskia Bricmont, who's an MEP. But you should distinguish that trade regulation from criminal law, which is still regulated at the domestic level in every single national member state. And so in Belgium, specifically, as far as criminal law is concerned, the import of products from forced labor, be it from China or the DRC or Bangladesh, is not yet seen as a criminal offense, and that's the thing I think we should repair and clarify in the near future. And as you said, and I think it just makes my point stronger. If you have trade regulations that actually prohibit trade with products of forced labor, you should also criminalize that in order to, make the case even more serious.
Okay, so I'll have to bring this into conclusion now. Thank you very much indeed. Thank you to our panelists here, and let's give them a very strong round of applause for taking their time. Thank you. Because it's being broadcast online.